previously dealing with narcotics cases. Then subsequently, when CNS was enacted, the jurisdiction of Shariat Court was taken away, and now it is with High Court. So it means Shariat Court jurisdiction can also be curtailed by Act of Parliament.
So with respect to Sharia Court, now it says clause 3 of 203DD says such other jurisdiction as may be prescribed by law. Now it is saying that there is a jurisdiction which has to be conferred. With the Sharia Court, the chapter provides what matters are to go to Sharia Court, what matters can the Sharia Court see. So this is all what the Constitution is providing. So there is here,
initially all the narcotics cases that will go to the Shariat Court. But after promulgation of CNS Act, now the Shariat Court can't hear those cases, and those cases are lie to the High Courts. So it means the jurisdiction of Shariat Court has been taken away, and which can be done.
My lord, what we have to see then is we have to examine this chapter and see whether what is
this
provided.
This cannot be done in the case of Supreme Court.
No, it cannot. It cannot be done in the case of Supreme Court, because if we look at 185, my lord, look at 185. Now 185, unless we read enlargement part independent of the preceding part, then does not permit any appeal coming to the High Court from either the Competition Tribunal or the election tribunals or all the other instances where appeal has been provided to the Supreme Court, because 185 there is no express authorization.
If you read it the way you're saying, then all those other laws.
ये 185 में सुप्रीम कोर्ट के ऑर्डर का जिक्र है?
सुप्रीम कोर्ट के ऑर्डर का
जी
सर, उसमें
देखिए आप ये ना, अगर आप कह रहे हैं कि जी इनलार्ज कर रहे हैं आप जुरिस्डिक्शन को, तो एपलेट जुरिस्डिक्शन 185 में दी हुई है, ठीक, उसको इनलार्ज कर रहे हैं आप, तो अब आप सोचें, आप कॉन्स्टिट्यूशन के एक प्रोविजन को वहां पे कर रहे हैं, ये थोड़ा सा उसमें या तो आप सिर्फ ये बता दें कि ये जुरिस्डिक्शन और पार कौन से हैं जो नहीं हो सकते 55 के नीचे.
When it says enlargement of jurisdiction,
रिवर्स लेना, आप तो एक्सेप्शंस पे जा रहे हैं, एक्सेप्ट सुप्रीम कोर्ट व्हेन एनलार्जमेंट है, हम उसको रिवर्स में लेते हैं. आप स्टार्ट करें जहां से वो स्टार्ट कर रहे हैं कि आप पावर नहीं कर सकते सुप्रीम को, वो कौन कौन सी जुरिस्डिक्शंस हैं जो नहीं कर सकते,
जो एनलार्ज नहीं कर सकते?
नहीं.
So I haven't got that.
देखिए आप 55 को प्लीज जरा पढ़ लीजिए.
Jurisdiction and powers of all courts. There's a comma then, except the Supreme Court.
So you can't create jurisdiction or create any new powers of the Supreme Court. Fine. So अब जब आप enhance नहीं कर सकते, reduce
enhance कर सकते हैं,
वो आप कैसे कर सकते हैं?
ये सर ये
नहीं, वो आप देखिए ना, वो तो आप कौन सी एक jurisdiction होगी जिसको आप enlarge कर रहे हैं ना?
Yes.
तो आप कौन सी jurisdiction को enlarge कर रहे हैं?
Appellate jurisdiction को enlarge.
यानी आप 185 में 184(3) की provision को ला रहे हैं?
तो हम ये कर रहे हैं कि because 185 में ये limitation नहीं है, because 185 में अगर ये हो कि for example 185 had said that in addition to what it says,
फिर देखिए, फिर इसको देने की जरूरत ही नहीं थी. देखें, फिर तो आप किसी भी सुप्रीम कोर्ट की प्रोविजंस दी हुई हैं, तो आप किसी प्रोविजन को भी एनहांस, यानी फिर तो आप हमें वो, फिर तो देयर इज नथिंग लेफ्ट टू इट.
इसको इस तरह से अगर देखें, अगर सिंपल ये होता एक्सेप्ट द सुप्रीम कोर्ट एंड the entry had ended where it says authorized by or under the constitution, full stop, then you could not do anything.
नहीं, इसमें जरा मैं ऐड कर दूं कि ये जो अभी कर रहे हैं अपील, this is 184(3). So I raised this question earlier that if you provide an appeal in 184(3), it is not conferring a new jurisdiction, it's enlarging the jurisdiction of 184.
So that could be one way of looking at it, that you enlarge that jurisdiction and then you apply an appeal and there is no limitation under 185.
Where
no
there is
limitation
a specific article of the Constitution providing an appeal, and that specific article is intact, it doesn't provide an appeal, then you cannot provide an appeal in another article by under the garb of enlargement. Because appeal is a separate jurisdiction.
And so you read 184 and 185 together and see whether there is any limitation. Where there is a jurisdiction which exists and you extend it.
185 jurisdiction is not a jurisdiction in the form of an intra-court appeal against an order of the Supreme Court. So there's a distinction. Now here there is already an existing jurisdiction under 184(3) that is simply being enlarged.
My lord, you read both of them together. I'll just, that's what I wanted. My lord, with this, I think one last question I have to address. Ladyship, you had a question about full
अगर
court.
आप कंक्लूड कर लें तो बेहतर होगा.
बस मैं वो full court वाली बात करके
आधा
conclude,
घंटा
but just
गुजर चुका है.
yesterday Mr. Faisal Siddiqui had made submissions.
ये
to ladies.
इसमें मिस्टर अटॉर्नी जनरल ये सेक्शन 6 जो है राइट टू अपॉइंट काउंसिल ऑफ चॉइस
जी जी.
इसका क्या मकसद है?
My lord, this is something which can easily be addressed. Now, of course, you have Order 26, Rule 6, where in exceptional circumstances you grant this power. As
नहीं
the
नहीं,
court-
यहाँ अगर आप राइट उसको दे देते हैं टू अपॉइंट काउंसिल ऑफ हिज चॉइस, तो इसका मतलब ये है कि कोई नया जो वकील आएगा वो फुल फ्लैज आर्गुमेंट करेगा, तो जो स्पिरिट ऑफ रिव्यू है जो कि अभी तक सेटल्ड हुआ हुआ है बाय दिस कोर्ट, वो तो खत्म हो
My lord,
जाएगा.
this can be easily dealt with, as I was submitting, with the use. Now, my lord, with this provision,
वो तो
my lord
आपने
can.
सेक्शन 8 में लिख दिया हुआ है ना, इट इज टू ओवरराइड एनी जजमेंट ऑफ एनी कोर्ट
मैं उसको
इंक्लूडिंग द
explain-
सुप्रीम
उसको-
कोर्ट और हाई कोर्ट.
उसको मैं एक्सप्लेन
वो
भी कर
खत्म
देता
हो
हूँ,
जाता
उसको ये भी एक्सप्लेन कर देता हूँ कि नाउ दैट विद द एडवेंट ऑफ टेक्नोलॉजी, एक तो ये कि ट्रांसक्रिप्ट्स बन जाती है, बट लेट्स लीव इट दैट असाइड. With this provision in mind, my lords can suitably amend Order 26 to say, require the councils to file their written briefs, for example. In addition to the pleadings, they file their written
That
briefs.
is already
and
given
so
in
that
the
will then
Supreme Court rules,
जी.
and that depends upon the court. If feel like
So उसको इसको अब रेगुलेट करने के लिए, फर्दर करने के लिए कि इसको कैसे इफेक्ट देना है, उसका ये तरीका हो सकता है.
इसमें तो you have given it as a right.
जी जी, मैं वही कह रहा हूँ कि ये राइट, नाउ दिस इज अ राइट एट वन एंड एंड देयर इज अ डिफिकल्टी दैट यू हैव जस्ट
ये तो
पॉइंटेड आउट ऑफ द
full-fledged
कोर्ट एट
case हो
द अदर
जाएगा
एंड,
ना,
उसको
full-fledged
बैलेंस किया जा सकता है.
अपील किया किसी और ने, रिव्यू दायर किया किसी और
मैं
ने,
उसी को एक्सप्लेन तो कर
वो कोर्ट के सामने फिर शुरू से
तो
ही
मैं
करेगा
यही
ना,
मैं
और
कह
फिर
रहा हूँ,
सेकंड अपील
मैं
इसको
यही
treat
कह रहा
किया
हूँ कि
जाएगा.
देन द कोर्ट विल गो बाय द प्लीडिंग्स, वो रिटन सबमिशंस हो
Would
सकती
that-
है. दिस इज समथिंग व्हिच आई अप्रिशिएट द
Would
डिफिकल्टी
that
दैट यू
be-
हैव पॉइंटेड आउट.
would that be a review stricto sensu, or that would be second appeal?
No. I mean, if it is in review, obviously for determining the review or deciding the review, the principles of review that you have in Order 26 will apply. Now, the
That
only
has been
difficulty that
settled
my
by
lord
this court is various
has
judgments.
pointed out, that there will
Various
be a
judgment on this.
different counsel arguing that case. I think in order to give
It
effect to
would be a
this section,
re-argument,
Order 26.
fresh argument of the case.
वो उसमें my lord आप Order 26 Rule 6 में ये amendment कर दें कि जी beyond written pleadings nothing new would be entertained and that will take care of everything.
Learned Attorney General, even if another litigant exercises the right of engaging a new counsel, he would be still bound by the same principles laid down by this court.
Yes, and
So he can't go beyond that.
on judicial
And
side
when we
you
allow a
can't.
new counsel to come, he also stays within the limits of
So
the
Joe
jurisdiction.
plead, he is bound by the pleadings which are before the court, and that would resolve that difficulty of a new person coming in, not being part of original proceedings. That might just
Mr.
resolve the
AG,
difficulty.
Mr. AG, it's Article 10 of the Constitution gives power, gives right to a person to appoint a counsel of his own choice. How can bar be put on a person that you should not appoint a counsel of your own choice? वो कहते हैं आज मुझे ये वकील पसंद मैं दूसरा रखता हूँ.
इसको फिर ये वही इसका जो बैलेंस है
It's
my
not
lord, वो
because
बैलेंस ये हो
इसके
सकता है
बाद-
कि आप अब जैसे कोर्ट रूम नंबर 1, I don't know if it is
Mr.
true or
Attorney
not, but
General,
there's a transcript of the
there
proceeding.
was some
I don't
sense
know.
when this rule was made, there was some sense. But with this, it will just expand the burden which is already on the shoulder of this court.
My lord, as I said, आप जो इसमें एक डिफिकल्टी जो मुझे आपके जो ऑब्जर्वेशन से नजर आ रही है वो ये है कि नया वकील आके कोई नई बात ना करे जो पहले नहीं हुई, यही डिफिकल्टी हो सकती है इन ऑल. सो उस पे इफ रूल 26 जो रूल 6 है ऑर्डर
ये
26
पता
उस
कैसे
पे आप ये
चलेगा?
लिखते हैं.
देखें ना, वही वकील आता है तो उसको तो आप ये कह देते हैं कि भैया आप पहले आर्ग्यू कर चुके हैं, नया वकील आएगा उसको क्या पता पिछले वाले ने
So
क्या
are you bind them by the pleadings which are already on the record?
अगर मजे की बात ये है कि ये वाला प्रोविजन नहीं चैलेंज कर रहे हैं, वो कह रहे हैं ये ठीक है. वकील कह रहे हैं इधर तो हमारी फायदे वाली बात है.
वकील कहते हैं ठीक है.
Your Ladyship, if I may now address that question that you had asked. It's a question that you raised from the first hearing, and it has troubled many that what becomes of that right when is a full court hearing this matter. My friend Mr. Faisal Siddiqui had also made submissions on this, so I adopt the submissions that he had made. This is not something which is which can easily be addressed, because as far as a particular court is concerned, if the entire court is sitting, conceivably there can't be any appeal, because there is no one left to hear the appeal in addition to.
No, but the question I think has been, perhaps with all due respect, misunderstood. The thrust of the question is not that. The thrust is that if there is a substantive right of appeal, and right of appeal is always substantive, that right vests when the petition is filed. 184(3) petition is filed, the right vests on that date. That is the settled law. Now, the thrust of the question is this. Because of this reason, and a right of appeal has to be mandatory, the power or the ability of the Supreme Court to fix, whether exercised by committee, collegium, whoever, to fix a matter before any bench of strength greater than, as presently constituted, 7, has been taken away. Because the right of appeal, being a substantive vested right, must prevail. So this is an encroachment upon the independence of the judiciary, that no bench, full court, तो बड़ी दूर की बात है, 9 member, 8 member, 10 member, 11 member, keep on counting, cannot be constituted. The hands of the court have been tied, even if it is a matter of the utmost national importance. It cannot be heard as presently constituted by more than 7. This is the question. Not कि full court बैठेगी तो full court में तो 60 के अगर 60 जज हैं तो 60 जज होंगे. Well, obviously बात है. That's not the thrust of the question. The thrust of the question is, which the question has been asked by my learned colleague from day one. You are affecting the independence of the judiciary to hear matters in respect of, you put a maximum cap, nothing beyond that. You can't go beyond that. Why you created this right of appeal? इसका क्या जवाब?
और इसके साथ
can it be,
just add on to this question?
If I may just say something, can it not be without taking extreme positions, be very reasonably resolved by saying we haven't prohibited a full court from ever meeting, nor is the law said so, nor that it should not be over a certain thing. We have spelt it out. If you, in your wisdom, which is the Supreme Court of Pakistan, considers to constitute a full court, so be it. So why could it not be resolved simply by saying this?
That's right.
Oh, but can the whole point is that it's a substantive right, access to justice. So the Supreme Court, in its wisdom, can say, too bad to your access to justice and substantive right. In our wisdom, the full court will sit, which means whatever we decide, no appeal against that. So the question is that, can the Supreme Court do that? When the law provides a substantive right, can the Supreme Court deny that right? Or when you deny that right, there is no issue with it, so we, in our wisdom, can decide that? And that goes to the whole point of this law, कि आपने कोई wisdom को question किया है, अभी यहाँ पे कोई problem नहीं हो रही wisdom के साथ.
Let me just briefly respond to this in addition to what my Lord the Chief Justice has just observed. This situation of this sort, and I'd come to what Justice Munib Akhtar has observed, this situation could also have, a similar situation could have arisen in these proceedings. For example, if somebody had, let's say, committed a judicial contempt in these proceedings, hypothetically, what would have happened? Now, it had to go before some judge. Now, if it had, because it had happened before the entirety of full court,
No,
It
the
could not
right-
possibly
But that's
go
the
before
point.
That's
national.
not a vested
That's-
right, right?
I'm coming
Right
to
of
it.
appeal is a
coming
vested
to-
substantive right.
I'm coming to it.
You think, are you,
उसके बाद
Attorney General साहब, I'm sorry to interrupt you, आप contempt of court, ये वकील या पार्टी का right है to commit
तो
contempt
उसकी
of
फिर
तो
court?
आप डायरेक्ट एग्जांपल देते हैं ना,
एक अपील भी होनी है।
अटॉर्नी जनरल आप डायरेक्ट एग्जांपल देते हैं कि ये केस इस केस की अपील कहाँ जाएगी? आप मफरूजों पे क्यों चल रहे हैं? ये भी तो हम केस सुन ही नहीं रहे ना। कोई ना कोई हमारे फैसले से खुश नहीं होगा, शायद सब ना खुश हों, हमें नहीं पता। उनकी राइट ऑफ अपील तो है ही नहीं। तो ये कानून ने कहाँ कहा है कि हर केस में अपील होगी? उन्होंने कहा एक किस्म के केसेस में जहाँ कम है वहाँ अपील होगी, राइट ऑफ अपील। कानून ये नहीं कह रहा है कि कानून ने उधर गए ही नहीं है, कानून उस जगह गए ही नहीं है।
Let's read section 5, please read it to see कि कानून क्या कह रहा है और किसको राइट दे रहा है। पढ़ें प्लीज सेक्शन 5।
जी, an appeal shall lie within 30 days from an order of bench exercising jurisdiction under clause 3 of article 184 of the Constitution.
184(3) की अपील लाई करेगी। इसमें तो कोई हमें कंफ्यूजन नहीं है ना, वे क्लियर।
Shall be read will be may. It's very simple. I mean, why do we have to? I mean, it's we have done it in so many cases.
One submission to this.
Again, let me make one question to you. The fact that in this case, the full court is hearing the virees. Okay? In this case, if the law is struck down, बात खत्म हो जाती है। मैं section 5 को। If section 5, if the law is declared intra vires, I would find it some rather odd for a petitioner to say, I exercise the right of appeal under section 5 for a declaration that the law including section 5 is ultra vires. So this particular case is an exception because here the very vires of that act are under attack, including section 5. इधर वो नहीं बात apply कर सकती। बात हो रही है if this law survives challenge, तो फिर जो सवाल है separation of powers और independence of judiciary का कि आपने एक मैक्सिमम कैप लगा दिया जी, 7 से ज़्यादा नहीं सुन सकते क्योंकि आपने एक सब्सटैंटिव वेस्टेड राइट दिया हुआ है। उसको किस तरह कोई कोर्ट एक किसी का राइट है वो टेक अवे कर ले बाय एडमिनिस्ट्रेटिव एक्ट? इज दैट व्हाट यू आर आर्ग्यूइंग?
Let me confess my mistake to constitute a full court. It should have been less than the half of the number of judges of the court, so the right of appeal, if the law was sustained, would have remained.
No, I said
let me finish my thought. Would have remained, so I am certainly guilty of that. But then I'm not alone in that. Then my colleague should not have sat in the bench at all. And it's so when 8 of them, same question was have been, if this law be sustained, where will the right of appeal go? So that is not your fault. If at all a fault has been committed, I'm the first to accept my mistake to do this, but there was in need of transparency and in need of a demand, it was done, and nobody objected amongst my colleagues that the full court should not be constituted. Similarly, I assume that none of them objected when 8-member bench was constituted. There too the right of appeal had disappeared. So effectively that had become redundant. Yes. They should have said, no, we will not sit, let a lesser bench be constituted, because if this law is sustained and if someone is aggrieved, where will his right of or her right of appeal go, or the government's right of appeal, or a political party's right of appeal? So इन मफरूजों से निकलें और conclude कीजिए, आगे खत्म करें, हमें सोचना भी है, लिखने भी दें।
Let me clarify for you, Mr. Azim, this is not a mafruza. I have said that this particular case is a special case in the sense and for the reason the very vires of this law are under challenge. It is not possible that if this law is sustained for a party challenging the very vires of the law to say, I exercise the right of appeal under section 5 for a declaration that this right of appeal that I have exercised is ultra vires the constitution. That would be completely nonsense. I am speaking of the future. I'm not speaking of this case. Because here the vires are under attack.
My lord, my brief response is this.
Suppose अगर ये law sustain कर जाता है, तो this issue can be resolved in the full court meeting. रूल्स में हम बना देंगे कि कितने बेंचेस होने चाहिए या नहीं होने चाहिए, अगर
अगर
फुल
लॉ
कोर्ट
से
होगा
हट के तो कुछ
तो
नहीं
उसके
आप
बाद
बनेगा।
है
लॉ से हट के तो
इसमें
कुछ नहीं
मेरा
कर
मेरा
सकते।
मेरा
Because
response simply
as
put, and
I
I'll conclude.
earlier said, I mean,
I'll
the
just conclude
law,
this.
through the rules, the law cannot be changed. That is your position.
So there's nothing
That's
that
one,
can be
but-
done.
but-
This
no,
issue,
but in-
you see, this goes if you flip it around.
इसको
If you
आप
एक
वो
second
खोल को
flip
देखो।
it around and you don't see it as a vested right, because as in an opinion which has been given, it doesn't matter about the vested right. So we flip it around and we see it in the context of what can the court do and what can't the court do. So you have actually capped in order to ensure that the right is always given to a party who files 184(3) petition, you have ensured that a certain quantity se zyada badi bench nahi banegi, depending on the strength of the court. Now, is that not some sort of an intrusion on how the court is to work? I mean, is that not something that the court has to decide based on factors that the court understands best?
No, I don't.
Whether
I don't.
whether this preclude the other part of the judges not to hear the matter. The matter was heard by some judges in the first instance, then it was heard by the other judges in the second instance.
In practical terms.
In practical,
And-
the
and-
entire
and-
judges have heard the matter.
And I think it's this right, I think it is a right being conferred on, and I had briefly shown your lordships that
Why are you
had this
putting
right
it on
been
us?
in
Why are you
existence.
putting it on us? Either you say,
Had
yes,
this-
please, there is a right, you cannot now deny anyone this right.
no,
Don't
going
tell us
by-
that you have hope and faith.
The difficulty
Please do
is-
that
the
accordingly.
difficulty
Please
is
be
that,
precise in what you
going
want to
by-
say.
Let me make your life
The
easy. I
difficulty-
put it upon myself. Let's end it. I take responsibility. Let's move forward. You've concluded the case or not?
I have, my
Okay.
lord, and I just say this towards the
So
end.
I first of all, let me compliment the petitioners who have fought valiantly to sustain my powers and and you and the others who want to undermine them. So, but thank you very much for
Thank you, sir.
remaining good humor till the very end, despite some very difficult questions. And if we have said anything, or any one of us, which may have upset anyone, we certainly did not intend to do so. Sometimes in the heat of battle, things are said which are not really, don't mean anything. So let us end in good humor. And does it conclude the matter, or is there anything left for us to say or do?
5 minutes, just two very quick points.
5 minutes, certainly. Aye.
Grateful, my lord.
Aye,
Grateful
thank
for your
you.
time. Thank you for your patient hearing.
My lord, on a very lighter side, the powers which have been exercised in promulgating this law are 1752 say so. It doesn't say so that 142 has been used, read with entry 55. So my humble submission is that discussion on entry 55 is little superfluous. And if your lordship may allow me to refer to 175(2),
By now we've memorized it.
We memorized it.
I know.
Make the point.
I know. The point is that, and I think I would be able to make a better point if I just read, because it has to be read together.
Right of reply, na?
See, very quickly. There shall be a Supreme Court of Pakistan, a High Court for each province, for Islamabad, and such other courts. So the provision is using Supreme Court and the High Court and other courts separately. And if you read 175(2), no court shall have jurisdiction save as is or may be conferred on it by the Constitution or by any other law. So when 1752 is read along with 1751, the word court does not include the Supreme Court. And if I may refer to your lordship's dissenting opinion in the Rawalpindi High Court Bar Association case, where interpreting various provisions of the Constitution, it has been concluded when the Constitution uses the words any court, that does not include the Supreme Court. So my humble submission would be that 1752, they cannot draw the power to legislate for the purposes of this law for Supreme
Okay,
Court,
point taken.
relying on 175(2).
Point taken.
And your lordship, again on a lighter tone, there is a world of difference between will
of the people versus the will of the parliament or will of the government. So that aspect has to be taken into consideration. And Your Lordship,
No, sorry, there isn't any. The preamble starts that the will of the people will be expressed through their chosen representatives, which is the parliament.
That is what my point is, the chosen, and then modifying the constitution by the will of the chosen representative has to be by 2/3 majority.
चलें वो तो
So
आगे हो
that
चुका है.
is what the principal point is. And Your Lordship, again, another point in the same context is that when the Constitution has intended to confer an appeal right, that has been specifically provided by the Constitution, and there is an appeal against in the case of Article 63.
नहीं, right of reply पे रहिए ना.
जी my lord, यही
ये
right
वही
of-
points आप दोबारा.
My lord, वो मैंने पहले नहीं raise किया था because this is a specific provision, the specific point that has to be taken into consideration. So these are the two major points that I just thought would be relevant, because under 63A, Article 5, 2035 and 2123, there is a right of appeal which the Constitution has provided. So when we read 185, there is no right of appeal which is specifically conferred, or 184. And my lord, last point very quickly is that there has been no answer or no argument to counter the point that this committee by section 2 and 3 has virtually modified Article 1843 provision. And in fact, the law itself, as your lordship was on a lighter tone saying, that if the Honorable Chief Justice doesn't fix the case, then the law itself does not provide that the committee, in how many days the committee will decide that the bench will be constituted, in how many days the committee can also likewise sit down on this. So this law has to really be seen from that perspective. And I think the solution lies in your lordship looking at the rules themselves rather than any outside body. I'm very grateful, my lord, for very good.
जी आबिद साहब.
जी आपकी इजाज़त से सर, फेडरल शरीयत कोर्ट की जो बात की अटॉर्नी जनरल साहब ने और माय लॉर्ड जस्टिस मंदोखेल ने, एक प्रोविजन फेडरल शरीयत कोर्ट के चैप्टर्स में कर दूं जिसकी वजह से रूल मेकिंग पावर को सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ नहीं किया गया. आर्टिकल 203A, ये देख लीजिए सर, बिकॉज इस पर सारी शरीयत कोर्ट के मुख्तलिफ प्रोविजंस की बात होती रही, लेकिन दिस इज अ वेरी क्रूशल 203A.
Capital A.
Capital A, my lord. The chapter starts 3A. The chapter 3A, 203A. Am I with your worship, sir?
Yeah.
The provisions of this chapter shall have effect notwithstanding anything contained in the constitution.
Yeah.
तो ये पहले ही constitution को, that's why जो rules
किसने
वगैरह
बनाया?
सर वो
कह दीजिए ना.
सर लेकिन
हिम्मत कर ले.
बिल्कुल बनाया, एक मार्शल लॉ के जमाने बना नहीं, लेकिन सर लेकिन इसको अपहोल्ड